You have the right to remain silent, but we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law.
Spinning the Law.
Spinning the law, spinning the law.
With attorney Kendall Coffey.
All right, ladies and gentlemen. Boy, that went psh. I like that, huh? You know, to get the band to stop playing on cue like that, it's like, you know, you see these rock and rollers, the guy with the guitar goes up and then comes down. That's what I do. It's behind the scenes. So if you're watching at Newsmax, you didn't see me do this. And if you're listening on the radio, you don't know what the heck I'm talking about. But you could picture, you know, any band you've ever seen, and the guitarist, the lead guitarist, like goes up and then psh, comes down. Anyway, so we're getting a hold of Kendall Coffey to go spinning the law, and we're going to talk at length about the Trayvon Martin case, and certainly DOMA and everything else that took place with the Supreme Court yesterday, the Proposition 8, DOMA, but I want to concentrate on Trayvon Martin. And by the way, Kendall Coffey is also an analyst for NBC, legal analyst, where he's talking about the Trayvon Martin case at length. He just sent me a text with his cell phone number, so he should be there. Okay, cool. All right, good. So as soon as we get him, we will let you know. In the meantime, I'll see you later. No, only kidding. I got to tell you, I can't wait to get his take on the testimony of Trayvon Martin's, and we found out it's not girlfriend, but it's female friend. There was no romance at all between the two, according to 19-year-old Rachel Gentile. So we'll have to, you know, we take that into consideration when we hear from her as well. And this creepy-ass cracker remark, I think, is so huge. I think it's huge. I think it counteracts any accusation of racism on the part of George Zimmerman, where we have none. We have no proof of that. But yet we have this. Well, no, wait a minute. Everything got redone here. Where's the? I can't find the cracker mosquito. Creepy. It's gone. Drum, mosquito, womp, womp, rim. No, it was, but it's gone. Oh, bottom right-hand corner. Yeah, there it is. Okay.
Creepy ass cracker.
Okay. Joining us now is Kendall Coffey, our friend, Spinning the Law. Hello, Kendall.
Hey, how are you?
I am so thankful that you are with us today, because I know your schedule is so busy, and I you know, every time you come on, don't think it's ever taken for granted. But today, wow, what a day we have today. So much to talk about. So let's talk about the Zimmerman case first. And I know you've been following it. And this 19-year-old Rachel Gentile. Now, what's your take on her? Because, you know, from the networks, all I get from CNN is, oh, she's believable, she's not believable, she's so much more polite today than yesterday. And they're missing, in my view, all the important stuff, because they don't want to go into the important stuff because they're in the tank for the prosecution on these networks. But not you, of course, sir. So go ahead. Tell me what you think.
Well, you know, I'm not in the courtroom. I've been watching live feeds continuously, so I've seen a lot of this witness, and so we don't actually know how the jury is reacting, because they're not on camera. They could be rolling their eyes. They could be just looking seriously and poker face. But here's where I think a jury would likely be with her, and it's kind of a mix. I think that the idea that Trayvon Martin was being followed by George Zimmerman is coming across. And by the way, that's consistent with other evidence, including the tone of some of the police statements that have not been brought into evidence yet. But whether or not George Zimmerman was following Trayvon Martin out of, you know, whatever motives, perhaps just being a good citizen and a neighborhood watch guy, that is not the ultimate issue. The ultimate issue, simply stated, is who threw the first punch. Because even if Zimmerman was following Trayvon Martin, misguided or not, that's not a crime. And it doesn't cause you to lose your right to self-defense in Florida or any other state. If Zimmerman was following Trayvon Martin, creepy whatever or not, and they meet face-to-face and they exchange words, that's not a crime so far. But if, in fact, Trayvon Martin throws the first punch, that allows Zimmerman, if a fight ensues and Zimmerman is getting beat up, that can create a right of self-defense. If Zimmerman threw the first punch, then he's committed an unlawful act. He has no right of self-defense. Did this witness clear up who might have thrown the first punch? I don't think so. And in the minds of some people, she's raised some issues as to whether maybe Trayvon Martin had some ideas or views of George Zimmerman. So the key thing is not who was following who. It's really who began the violence that led to a tragedy that night.
I couldn't agree with you more. And what I took away from this, and I'm biased. I think that George Zimmerman, based on the evidence I've seen pre-trial, had a right to defend himself. But what we've seen here is the woman changed her testimony. She told one person one thing and the other person the other thing with regard to what she heard George Zimmerman say to Trayvon. She does say, and I think this helps the defense, that Trayvon said something first, like, why are you following me? But she also said, and this to me is important. Now, maybe you'll disagree with me, but so much has been said about and implied with profiling. They weren't allowed to say racial profiling, but profiling, and and every person that he gave a 911 call to was a black suspect. But it was Trayvon Martin who referred to George Zimmerman as a creepy ass cracker. And at the end, the last few minutes of the questioning that lasted almost 6 hours of this witness, the defense harped on that and said, is that derogatory towards white people? She said no, but she admitted that people she hangs with, people she knows, people she lives with, people she associates with, call white people crackers. And then when asked, so Trayvon Martin does also, and then she paused for, 10 seconds, 15 seconds, and said something like, not necessarily. But she already admitted that in a casual context on the phone, he referred to him as a cracker. So I think that is very damaging for Trayvon Martin.
Well, I think it hurts the prosecution because without some explanation, and you remember the prosecutor in his redirect of Rachel Gentile tried to start to export cultural differences, and then he quickly realized that this was not the witness that was going to be able to understand and explain cultural differences to the jury. Somehow the prosecution has to do some damage control here because an average person who's not part of the Trayvon Martin's community is going to believe that maybe he had some kind of feelings about people that look like George Zimmerman that could have prompted Trayvon Martin to throw the first punch.
Right.
And the prosecution needs to deal with that. They weren't able to deal with it in redirect. The prosecutor wisely changed the subject because he realized this witness wasn't going to be able to solve his problem. Don't be surprised if some other witnesses that we're going to hear from don't get into a little bit of an attempt to bridge the cultural issue, including perhaps even Trayvon Martin's mother. Not usually the best way to solve a problem for a prosecutor, but they've got to do something to explain those words, because right now the only truly offensive words that we've heard referred to were not comments made by George Zimmerman, were some very uncomfortable words attributed to Trayvon Martin.
Absolutely. I'm so glad you're saying this. We're talking to Kendall Coffey here on the Steve Malzberg Show. And in addition, before we move off of this witness, she admitted she perjured herself in the past. It might have been considered insignificant perjury in the context of everything, but she also admitted when the more importantly, and this is something else that at least CNN, when I say the network, CNN and MSNBC, which is what I'm watching, when the defense attorney asked her, when she heard the phone drop or whatever, and she heard a scuffle, he said, for all you know, Trayvon Martin could have been putting his fist into the face of George Zimmerman at that point and punching him, right? And she basically said, yes, sir. So what did this witness give them?
Well, no, what she gave them was a clear picture that George Zimmerman was pursuing Trayvon Martin and that Trayvon Martin was trying to get away. I think she gave them that.
But she was the star witness. I mean, that's not, like you said, you can't convict on that.
You can't convict him on that. But remember that George Zimmerman, through his statements, insisted something that's very much to the contrary. Zimmerman said, among other things, that he was going back to his car, his truck, and Trayvon Martin jumped out of the bushes and attacked him. One of the realities of self-defense cases that the jury's going to have to sort through is that when people are asserting self-defense, they sometimes can't help adding a few things to their account that maybe aren't true, Steve. And so it is possible that the accounts that George Zimmerman gave to the police have some things that are true and some things that are not true. And how will a jury react to that? Was George Zimmerman getting pretty beat up? I mean, I think almost everyone's going to have to concede that. If he had said simply, yeah, I followed him, I shouldn't have, I thought he was up to no good, we'd had some break-ins, we got into an argument, and then he smashed me in the nose, and before I knew it, I was being beaten within an inch of my life, and I shot him.
Well, did he not say...
If that had been his explanation, it would have been consistent with the known evidence, and it would have been a valid self-defense.
Well, he
admitted some additional facts that he added that may or may not be consistent with other testimony.
But Kendall, he did admit, and even to the non-911 operator, he did admit that he was following him to a certain extent, and then I guess maybe he eventually said that he stopped following and then was broadsided by Trayvon or whatever. But this girl indicates a conversation. But is not the follow? Did he not admit that he was following him for location purposes for the sake of the police?
Yeah, yes and no. But if the prosecution brings out, which they might, the details of George Zimmerman's statements to the police. Zimmerman voluntarily talked to the police without a lawyer.
Right.
Bottom line, that's a mistake.
Right.
Because Zimmerman's got some details in there that are just not consistent. Is it enough to get him convicted? Well, the prosecution hopes so, because what they got today from Rachel Gentile has some major gaps in it.
Yeah, no, absolutely. All right, let's move not on, but backwards to yesterday's rulings from the Supreme Court, and let's start with DOMA. Your take on that?
Widely, if not universally, expected. The original signer of the legislation, namely then President Bill Clinton, even some of the Republicans joining it, Ted Olson, David Boies, the two major adversaries from Recount, all supported the invalidating DOMA. That was not at all surprising, and in fact, there was a feeling that it could have even been more than 5 votes, because DOMA is a federal law that many see as sort of being inappropriately intrusive upon the state prerogative to define what is and what is not marriage. So that part was widely expected.
All right, well, let me ask you about the tone. Many, including Justice Scalia in his dissent, took exception to the tone in the majority opinion written by Justice Kennedy. And I ask you this because you've read many more opinions than I have. And basically, Scalia accused Kennedy of saying that anyone who did not vote with the majority on the court was an enemy of humanity, and that they, and implied or said outright that they basically have to have something against gay people, because there's no other possible reason to not vote to dismantle DOMA. So do you agree that the tone in the majority opinion was over the top, and that it was the kind of the public debate and the political debate has entered into the court now?
Well, I think that the tone was certainly very strong. I don't know that. I mean, Scalia was obviously very sensitive to it because he's not personally anti-gay. And he doesn't like the idea that because he votes in accordance with a certain philosophical view of the United States Constitution, we all know that Scalia believes that the Constitution basically should be interpreted as it was originally written. It has nothing to do with his attitude toward minorities. That being said, I think Scalia was somewhat offended. The tone that was written was strong, but I think in some sense the Justice Kennedy, who has been involved in decisions before, that, for example, the Texas sodomy case, which we remember very well,
right,
was authored by Justice Kennedy. I think he's viewing this as a question where he wanted to make a relatively strong statement, get the Supreme Court out of this issue for the foreseeable future, and let the states deal with it. And I think in Kennedy's mind, he's hopeful that this issue will cease to be a major controversy and will cease to be a source of division, and that the states will one by one eliminate barriers to same-sex marriage. But that part of it surprised me. On the other hand, everything about this issue is emotional, and it's something that even people in the court who obviously respect each other have strong disagreements about.
All right, we're talking to Kendall Coffey. Let's move finally to Prop 8, and the court sent it back. And what I was told by a lawyer for the group that was in court defending Prop 8 was that, hold on, Governor of California, not so fast, slow down the boat, don't issue the marriage certificates, because according to the California Constitution, he claims, and I have no reason to doubt him, that only an appellate court can overturn Prop 8. And since the appellate court approval of the lower court decision was vacated by the Supreme Court yesterday, which said they should not have heard it because there was no standing there either, that it's just a single judge is ruling that stands now, so that should not change anything. So your take on all of it?
Well, literally, that's true. You have a single district judge's decision. The Supreme Court took what some would say was not the most ambitious or audacious or boldest path by ruling on standing. I think your listeners know what standing it means. It means that the person who has the right to bring the case is not the one who brought the case, and that therefore the Supreme Court's going to decide that they don't have jurisdiction, and that was applied to the Middle District Court. So I think the person you spoke to has an intriguing point. But what the practical impact is going to be is that, given the weight of events, the pages of history seem to all be turning in one direction. My sense is that while the point you heard is technically a correct one, I think that most public officials in California are going to treat Proposition 8 as having effectively been invalidated, even if only by a single federal district judge.
Gotcha. Kendall, really appreciate your time, sir. We'll watch for you on NBC with your legal analysis of the Zimmerman trial, and if everything works out well, no, next Thursday is the 4th of July, so hopefully we'll speak to you in a couple of weeks. Have a great holiday, sir.
Okay, Steve. Thanks for having me on.
Oh, my pleasure. Thank you. Kendall Coffey.